This is Michael Popok, Legal AF, with some earth-shattering news out of the Fifth Circuit, who has now declared open hunting season on women and children by striking from the books as unconstitutional a 30-year federal ban passed by Congress to prevent people who are the subject of domestic violence restraining orders from possessing firearms. Sounds like a reasonable set of regulations, a reasonable set of laws on the books, but the Fifth Circuit doesn't agree, led by two Trump appointee judges and one Reagan appointee judge. They've decided, in a backflip from an earlier decision by another panel of the Fifth Circuit, that that law is now unconstitutional under the U.S. Supreme Court's ruling in New York Rifle versus Braun last year. Why? Because New York Rifle versus Braun, which was Clarence Thomas and the other right-wing MAGA's coup de grace, their grand opus, says effectively that you are to evaluate whether a restriction or regulation on the books is what the framers of the Constitution back in their day, or what the nation's history, the nation's historic tradition of regulation about firearms, if it's consistent with that, the law stays on the books. If it's inconsistent with what primitive people back in the 1700s and 1800s felt about guns, it comes off, it gets stripped away from protections. This is a tremendous vote for violence against women by the right-wing extremists in this country. There's no other way to interpret it. The National Coalition of Domestic Violence says that every year, 600 women are shot dead by their intimate partner. And the presence of a gun in the relationship or former relationship increases the chance of that happening by over 500%. That is the public policy that the Congress 30 years ago was concerned about in balancing constitutional rights against the growing tide of violence against women. And what is missing in this whole analysis about, well, what would the gun-toting people of America back in the 17 and 1800s have done? That's not the right question, because that misses a very important piece that you would have thought at least one of the judges who is a woman on that panel, Edith Jones, in striking down the law, would have picked up on. Women in the 1700s and 1800s were considered chattel. They were considered owned by their husbands. They did not have independent rights of protection. So, of course, men in the 1700s and 1800s could do as they pleased with women. Women weren't considered anything but owned chattel or owned cattle, if you will. And so to say that gun regulation, Second Amendment, trumps all gun regulation to protect effectively women and children, I mean, yes, it's intimate partners, so it's more expansive than that, totally misses the point. There were no protections on the books in the 17 and 1800s or even 1900s about transgender people, homosexual people, members of the LGBTQ plus community. Children were considered even less than women at that time. So how do you balance? That is what a court is supposed to do. How do you balance Second Amendment rights, which are, yes, have been upheld time and time again by this U.S. Supreme Court and prior U.S. Supreme Courts, with the public policy about the realities of domestic violence? What did this Fifth Circuit panel decide to do? They didn't do any balancing at all. They just sided completely with the rights of gun owners and said, our hands are tied, an interesting choice of phrase. Our hands are tied because under New York Rifle versus Braun, the U.S. Supreme Court says we got to go back to our historic traditions of how gun regulation happened, and we can't find a historic tradition of protecting women and children from domestic violence. I mean, that is effectively the analysis in this 26-page opinion. The Department of Justice, of course, is up in arms. Merrick Garland has already issued a statement that they're going to be appealing this to either the full Fifth Circuit, which would be all judges, the en banc judges of the Fifth Circuit, or a direct appeal to the U.S. Supreme Court, who are now going to have to clarify just what they meant in New York Rifle versus Braun, with all gun regulations have to be analyzed along the nation's historic traditions of firearm regulations. Okay, what are you going to do now? What are you going to do when the focus of the law that has now been struck down by the Fifth Circuit as unconstitutional was focused on a class of people or a subset of people or half this country, if you will, that did not have those types of protections back in the day? What do you do there? Are we going to continue to let the founding fathers rule from the grave, legislate from the grave, and tell us how to run a modern society with the values and the problems and the issues that are now present, that were not present back then? Or are we just going to say, well, they used muskets and flintlock guns and pistols back in the day, so the founding fathers were okay with abusing women and children and other people, so we'll just let that keep going? Is that the nation? Is that our democracy? Our constitutional republic? Is that what it's supposed to be? Well, we're going to find out, because this case is going to go up to the U.S. Supreme Court, and on the issue of whether 18 U.S.C. Section 922, which prevents anyone who is the subject of a restraining order, who had a hearing, who has been found to have been harassing, stalking, or threatening an intimate partner or child, and there remains a credible threat of violence, can or cannot own a gun. That is now going to go up to this U.S. Supreme Court. And just to put this in further context, because it's, again, the irony continues, this is the same week that Merrick Garland, who ordered 2 years ago that the Alcohol, Tobacco, Firearms, and Explosives Bureau issue their gun crime report. Their second volume of the gun crime report just came out. And here's what we learned from that about guns in America. There is a rise of ghost guns, which is the manufacture at home, basically do it yourself. Like, remember home brewing beer? This is home making your gun. That gun that comes out of that process does not have a serial number. It is untraceable. It is considered a ghost gun. So we have a rise over the last 5 years in ghost guns. We have a rise of the conversion of semi-automatic and non-automatic weapons to automatic weapons. We just saw it in Sacramento with the use of a device that created an automatic weapon out of a semi-automatic weapon. So we have that as the second major finding of the report. And 3, we have illegal gun trafficking, where within 3 years of a gun coming online, many of them are being used in a crime, which means that there's probably a straw man who's buying the gun for somebody else who is the criminal. So somebody who's not a criminal, is not in a database, is able to pick up a gun, turns it over eventually to somebody who is a criminal, and the result is it's being used in a crime. They're actually seeing a 5-time increase from 2016 to 2021 in non-automatic weapons being converted into semi or automatic weapons. 500% increase. There are now 20,000 ghost guns on the streets, up from 10,000. So a 100% increase in ghost guns during the last 5 years. And the new biggest statistic is that the crime that is committed, the end user of that is basically not the original purchaser, but is somebody that's acquired it over the last 3 years. That's the backdrop of guns in America right now, and the volume of guns in America. And now you've got courts like the Fifth Circuit Court of Appeals who thinks it's okay to strip away another layer of protection for the vulnerable in our society, for the LGBTQ community, for women in our society, for anyone that's considered an intimate partner, that used to have at least have the presence of mind, knowing that if she got or he got or they got a temporary restraining order, that the result would be that the other person would not have weapons. That is now gone as of the Fifth Circuit's ruling. Going by the Department of Justice's announcement, it looks like they'll be taking this right to the U.S. Supreme Court and will be following it on Legal AF. This is Michael Popok reporting.
The best part of waking up? MAGA tears in my cup. Check out the new MAGA tears mug available now at store.MeidasTouch.com. That's store.MeidasTouch.com.